All right, diving in today, folks, we're going deep on something super important, especially if you're anywhere near the psychology world here in California. We're talking about the legal side of things, the rules of the road.
Yeah, absolutely. The essential legal and regulatory landscape.
And for this deep dive, we've got two main sources in the mix. We're looking at practice malpractice, and then, of course, the official stuff from the California Board of Psychology itself.
Right, the straight from the source material.
And our mission today, what we really want to do is give you a clear picture, no jargon, of what exactly malpractice is. How do you know it when you see it? What are the actual rules for practicing? And then, we've got all these different types of professionals,
Different roles.
psychologists, associates, testing technicians. What are they allowed to do? What are they not allowed to do? So hopefully by the end of this, you'll have some real aha moments about how this all works. You ready to jump in?
Let's do it.
Let's start with the big one, the one everyone's at least a little bit afraid of, malpractice. When we talk about malpractice in psychology, what are we really talking about?
Okay, so at its core, we're talking about a civil lawsuit. Somebody's taking somebody else to court. And to win that lawsuit, the person suing, the client, has to prove, basically, that it's more likely than not that malpractice actually happened.
More likely than not. That's interesting. It's not like, beyond a reasonable doubt, like on a criminal case.
Exactly. It's a lower bar, but still, they got to prove it. And a big part of that comes down to this idea of the standard of care.
Standard of care. That's a phrase we hear a lot. What does that really mean in practice?
So imagine you're a psychologist, right? The standard of care is basically the level of skill and care that a reasonably competent psychologist in the same situation as you would use.
Okay, so it's not just like some universal rule book. It depends on the situation, the context.
Absolutely. It can change. Like what's considered acceptable practice in one situation might be totally off in another. And there's no one way to figure out what that standard is.
Right. It's not like there's a checklist, is there?
No, not at all. Sometimes you might bring in expert witnesses to court, other psychologists who can say, hey, this is how we normally do things.
Yeah.
Or sometimes there are actual laws that spell out some parts of the standard. Or even, guidelines from professional organizations, what they consider to be best practices.
And what about insurance companies? Do they play a role in this?
They do. Sometimes what insurance will cover or won't cover can actually help define that standard of care.
Yeah.
So it really is kind of a living thing, the standard constantly evolving and influenced by all these different factors.
I see. So it's not fixed in stone. It's more like what a reasonably competent psychologist would do, given all the specific circumstances. Okay. So let's say someone feels like they've been wronged, like a psychologist has messed up. What do they actually have to prove to win a malpractice lawsuit? What are the boxes they need to check?
Okay, so there are four main conditions that have to be met. First off, there has to be an actual professional relationship. Like the psychologist agreed to treat this person, which means they have a legal duty to care for them.
So it's not just like you bump into a psychologist at the grocery store and give them advice.
No, not at all. There has to be a formal agreement in place, like a contract.
Yeah.
Okay, second condition, the client has to show that the psychologist messed up somehow, that they violated that standard of care we were talking about.
So they did something or didn't do something that a reasonably competent psychologist would have done differently.
Exactly. But here's the thing. It's not enough just to show that the psychologist screwed up. The client also has to prove that they were actually harmed because of it.
Okay, so that's the third condition, right? Real, actual harm, not just, oh, I didn't like the way the therapist talked to me.
Yeah, it has to be a real tangible injury. Like maybe they got worse because of the therapy, or they missed out on job opportunities, something like that. And then finally, the fourth condition is what lawyers call proximate cause.
Proximate cause. What's that all about?
It basically means that the psychologist's actions or inactions directly led to the harm. Like there has to be a clear, straight line from what the psychologist did to the injury the client suffered.
Okay, that makes sense. It can't just be a coincidence. So let's say, I don't know, a client starts feeling more anxious after a session, but then it turns out they also had a big fight with their partner that day. That wouldn't necessarily be the therapist's fault, right? Even if the therapy wasn't helpful overall.
Exactly. You got to be able to show that it was the therapist's actions that actually caused the problem. So you see, it's not always so straightforward.
It's complicated. I see that. Okay, so let's imagine the worst case scenario. Someone sues for malpractice and they win. What kind of consequences are we talking about here? What kind of compensation does the psychologist have to pay?
Well, Practice and Malpractice, the book we're looking at, it talks about three main types of damages that can be awarded.
Okay, hit me with them.
The most common one is compensatory damages. The idea here is to try to put the client back in the position they are in before the whole mess happened.
Like makes them whole again.
Exactly. So this could include things like money they lost from not being able to work, medical bills they had to pay because of the harm, even compensation for pain and suffering, emotional distress, stuff like that.
So it's not just about the financial hit. It's about acknowledging the full impact of the harm.
Exactly. Then there are these things called nominal damages. These are kind of interesting. They're basically a slap on the wrist for the psychologist.
Like, you did something wrong, but not that wrong.
Exactly. It's more like a symbolic thing. Like the court saying, yeah, technically there was some negligence, but it didn't really cause any big measurable harm.
So the client gets a little something, but not much.
Right, right. And then finally, there's the nuclear option, punitive damages.
Punitive damages. That sounds serious.
It is. These are meant to punish the psychologist, not just compensate the client.
So when would a court actually award punitive damages?
Well, only in really extreme cases, when the psychologist's actions were so reckless, so malicious, that the court wants to make an example out of them.
Like send a message.
Exactly. It's like,
Yeah.
we're not just going to make you pay for the damage, we're going to hit you where it hurts so you and everyone else learn a lesson. But honestly, punitive damages are pretty rare in malpractice cases.
Okay, good to know. So shifting gears a bit, let's talk about what psychologists can do to protect themselves. What are some best practices for minimizing the risk of a malpractice suit in the first place?
That's where really understanding your responsibilities comes in. The experts really emphasize two things.
All right, lay it on me.
Number one, you've got to know the rules of the game. I mean, every single legal and ethical standard that applies to your practice here in California. You can't follow rules you don't know.
Makes sense. Ignorance is no excuse. Right?
Exactly. And then the second big one is, drum roll, please, good record keeping.
Record keeping, the bane of every therapist's existence.
I know, right? But seriously, keeping detailed, organized records of your work, that's your best defense.
So if a client ever comes after you, you can say, look, here's what I did, here's why I did it, and it was all above board.
Yeah, exactly. It's like your professional alibi. Your notes are your backup, your proof that you are doing things the right way.
Makes sense. Okay, so in the materials for this deep dive, they had some practice questions that I thought were really helpful in illustrating some of these points. Let's tackle one of them, shall we?
Let's do it.
Okay, so here's the scenario. You're a psychologist, minding your own business, when bam, you get a subpoena. Someone wants you to hand over a client's records, but the client is like, no way, those are confidential. I don't want you sharing them.
Right.
What do? What's the right move?
Oh, this is a classic. It happens all the time.
Yeah.
And it's tricky because you've got this legal obligation to respond to the subpoena.
Right, you can't just ignore it.
Nope. But at the same time, you have an ethical and legal duty to protect your client's privacy.
So you're
Right.
stuck between a rock and a hard place. What's the solution?
So the first thing you do is reach out to the attorney who issued the subpoena.
Like, pick up the phone and call them.
Yeah, or send a formal letter. But you got to get in touch with them ASAP. And what you're asking for is a release. Basically, you're saying, hey, my client doesn't want me to share these records. Can you let me off the hook?
So you're basically trying to get out of having to go to court.
Exactly. But here's the catch. The client doesn't actually have the power to ignore the subpoena. The subpoena is a court order, and it's addressed to you, the psychologist.
Oh, wow. So the client can't just say, no, I don't want you to go.
Nope. So unless that attorney gives you a formal release, you still have to show up in court when they tell you to.
Okay, so you show up in court and the attorney is all, give me those records. What then?
That's when you assert the client's privilege. Basically, you're saying, look, I'm here because I have to be, but I can't share this information because it's protected by confidentiality.
So you're acknowledging the court's authority, but you're also standing up for your client's right to privacy.
Exactly. It's a delicate balance.
That's super helpful to know because it's a situation that a lot of therapists might find themselves in. Okay, let's tackle another one of those practice questions.
Hit me.
This one is about what a client actually has to prove to win a malpractice case. So here are a few options. They have to show that the psychologist could have caused them harm, that the psychologist deliberately did something harmful, that the psychologist's actions directly caused a demonstrable injury, or that they can prove negligence beyond a reasonable doubt. Which one is it?
Okay, so the key here is that the client has to show that the psychologist's actions directly caused a real demonstrable injury. Or that they can prove negligence beyond a reasonable doubt. Which one is it? Okay, so the key here is that the client has to show that the psychologist's actions directly caused a demonstrable injury. Or that they can prove negligence beyond a reasonable doubt. Which one is it?
Okay, so the key here is that the client has to show that the psychologist's actions
demonstrable injury.
And by demonstrable, you mean like it can be proven.
Exactly. It's not enough to say, well, the therapist made me feel bad or they could have done something better.
It has to be concrete.
Right. There needs to be that clear cause and effect, and the harm has to be real, something that can be documented and measured.
So that goes back to what we were talking about earlier with those 4 conditions for a successful malpractice claim: the harm and the proximate cause.
Exactly. And remember, the standard of proof in a civil case like this is preponderance of the evidence, meaning more likely than not. It's not as high as beyond a reasonable doubt, which is what they use in criminal cases.
Right. So it's a lower bar, but still, the client has to make a strong case. They can't just say, well, I think the therapist messed me up.
Nope, it has to be more than just a feeling. Okay, so we've covered a lot of ground with malpractice. Ready to move on to the bigger picture, the legal framework that governs the whole profession of psychology in California.
Yeah, let's zoom out a bit and see how it all fits together.
All right, so the key player here is the California Board of Psychology.
The Board of Psychology, what's their deal?
Well, they were created back in 1958, and they're part of the Department of Consumer Affairs.
Consumer affairs. So they're all about protecting the public?
That's exactly it. And their mission, as spelled out in the Business and Professions Code, Section 101.6, is to protect the health, safety, and welfare of the people of California when it comes to psychological services.
Okay, that makes sense. So they're the watchdogs, making sure that everyone who practices psychology in California is competent and ethical.
That's the idea. And they do this in a few different ways. First, they set the bar, the minimum qualifications for getting licensed as a psychologist.
So like what degrees you need, what kind of experience, that sort of thing.
Exactly. And then, of course, they're the ones who give the exams, the ones you got to pass to get licensed. And after you're licensed, they keep an eye on you.
Oh, so they don't just disappear once you get your license?
Nope, they're still there. They receive complaints from the public. They investigate allegations of wrongdoing.
Yeah.
And they can take disciplinary action if a psychologist screws up.
So they can suspend licenses, revoke licenses, that sort of thing.
Exactly. And they can also make sure that psychologists are keeping up with continuing education requirements, things like that.
Okay, so they're pretty powerful. So let's say someone's listening to this and thinking, hey, I want to be a licensed psychologist in California. What do they need to do? What's the process?
All right, so buckle up because it's a journey. According to the Business and Professions Code, Section 2914, the first thing you need is a doctorate.
A doctorate, like a PhD or a PsyD?
Yep, exactly. And it can't just be any doctorate. It has to be in psychology, educational psychology, or education with a specialization in counseling or educational psychology.
So you can't just get a doctorate in, like, history and then say, oh, I'm a psychologist now.
Nope, not going to fly. And here's another thing. The school you get your doctorate from has to be accredited.
Accredited? What does that mean?
It basically means that the program meets certain quality standards set by an accrediting body. So it's not just some fly-by-night operation. And even once you have that doctorate, you're not done yet. You also need at least 2 years or 30,000 hours of supervised professional experience.
So you can't just graduate with your doctorate and hang up your shingle.
Nope. You got to put in the time working under the supervision of a licensed psychologist. And then, of course, there are the exams. You got to pass all the licensing exams that the board gives.
So it's a long road. You've got to put in the work.
Absolutely. And California also has some specific areas of knowledge that they want psychologists to have training in.
Oh, really? Like what?
Well, for example, you have to have training in human sexuality, child abuse assessment and reporting, dealing with alcohol and drug dependency, domestic violence, suicide risk assessment and intervention, and working with older adults.
It sounds like they really want to make sure that psychologists are prepared to deal with some of the toughest challenges that people face.
Yeah, exactly. They want to make sure that psychologists have a solid foundation in all these different areas.
Okay, so let's say someone thinks, forget the rules. I'm going to practice psychology without a license. What happens then?
Well, the Business and Professions Code is pretty clear about that. Section 2903 says it's illegal to practice psychology or even call yourself a psychologist in California without a license from the board.
So no pretending to be a psychologist.
Nope, not allowed.
What about psychologists who are licensed in other states? Like what if they're just visiting California for a short time and want to see some clients?
Well, Section 2912 of the code allows for that. A psychologist who has a valid license from another state can practice in California for up to 30 days in a year.
So it's like a temporary pass?
Yeah, exactly. It's meant for short-term situations, like
Huh.
if they're giving a workshop or doing some consulting.
Okay, that makes sense. But what if they want to move to California and set up shop permanently? What do they have to do?
So for that, they need to follow the process outlined in Section 2946. Basically, if they've been licensed in another state or a Canadian province for at least 5 years, and that state has similar licensing requirements to California, they can apply for a license here.
So they don't have to start from scratch.
Right. But they do have to pass the California licensing exam,
Hmm.
the supplemental one that focuses on the laws and regulations specific to this state.
Okay, that makes sense. So they have to show that they know how things work in California.
Exactly. And there's a cool provision that allows them to practice for up to 180 days while their application is being processed, or from when they start living in California, whichever comes first.
Oh, that's interesting. So they can get started even before they have their full license?
Yeah, as long as they meet certain conditions. And there's another interesting twist. The board can actually waive the exam requirement in some cases.
Really?
Yeah.
When would they do that?
Well, for example, if the psychologist already has a diploma from the American Board of Professional Psychology, which is a really high level of certification.
So they're basically saying, look, you're already super qualified. You don't need to take our exam.
Exactly. They recognize that some people come in with a ton of experience and expertise. Okay, so we've talked about licensed psychologists, but what about psychological associates? Where do they fit in?
Yeah, what's the deal with them?
So psychological associates are a little different. They're registered with the Board of Psychology, but they work under the supervision of a licensed psychologist.
So they're not fully independent.
Right. And to become a psychological associate, you need to have at least a master's degree in a relevant field of psychology, or you have to be a doctoral candidate who's finished at least 3 years of grad school and passed their preliminary exams,
Okay.
or you already have a doctorate that qualifies, and their registration has to be renewed every year.
So it's a bit like an apprenticeship.
Kind of, yeah. The idea is that they're getting experience and training under the guidance of a more seasoned professional. And the licensed psychologist who's supervising them, they're the ones who are ultimately responsible for making sure the associate is providing good care and following all the rules.
So the supervisor has a lot of responsibility.
They do. And they can't supervise more than 3 associates at a time. And a big change recently is that there are no longer any restrictions on where a psychological associate can work.
Oh, that's good to know. So it's a lot more flexible now.
Exactly. Okay, so we've got psychologists and associates. Now, what about psychological testing technicians? What do they do?
Yeah, what's their role?
So, testing technicians are really focused on the technical aspects of assessment.
So like giving tests and scoring them.
Right. They can administer and score objective tests like personality tests or intelligence tests, and they can make observations of behavior during the testing process.
Okay, so they're kind of like the data collectors.
That's a good way to put it.
Mhm.
But here's what they can't do. They can't choose which test to give, they can't interpret the result of the tests, and they can't write reports or give feedback to the people being tested.
So their role is pretty limited.
Yeah, it's very specifically defined. And to do even those limited things, they have to be registered with the Board of Psychology or be in the process of getting registered.
So they still have to meet certain standards.
Absolutely. And like psychological associates, they work under the supervision of a licensed psychologist.
So there's always someone overseeing them, making sure they're doing things right.
Exactly. The supervisor has to be physically present, like in the same building, and they have to be available if the technician needs to consult with them.
So the psychologist is ultimately responsible for the technician's work.
That's right. Now, to become a registered testing technician, you usually need at least a bachelor's degree in a relevant field, or you have to be enrolled in a relevant graduate program, and you have to complete 80 hours of specific training in test administration, scoring, and observation.
So it's not just something you can walk in off the street and do.
Nope. You got to know what you're doing.
Yeah,
And you have to pay a registration fee and get a fingerprint background check.
it makes sense. You're working with sensitive information.
Yeah.
And they have to renew their registration every year, right?
Yep, every year. And they have to tell the board if they've been convicted of any crimes or had any disciplinary action taken against them.
Okay, so there's a lot of accountability built into the system.
Yeah, they want to make sure that everyone who's involved in providing psychological services is trustworthy and competent.
It's really fascinating to see how the California Board of Psychology has created this whole system with all these different roles and all these different regulations.
It's all about protecting the public, making sure that people who are seeking psychological services are getting quality care from qualified professionals.
All right, so let's wrap things up. We've covered a lot of ground today, haven't we?
We have. We started with the nitty-gritty of malpractice, what it is, how it's proven, and how psychologists can protect themselves. Then we zoomed out and looked at the whole legal framework for psychology practice in California.
We talked about the requirements for becoming a licensed psychologist, the roles of psychological associates and testing technicians, and how the Board of Psychology oversees it all.
And the main takeaway, if you're involved in the world of psychology in California, whether you're a practitioner or a client, understanding this legal and ethical landscape is absolutely crucial.
Absolutely. Knowing the rules of the game is essential. And as we said at the beginning, for our listeners who wanted a quick but thorough understanding of all this, well, hopefully, this deep dive delivered just that.
And maybe spark some of those light bulb moments, those ahas,
Yeah.
about the responsibilities and the potential pitfalls in this field.
Exactly. And all this talk about the standard of care, it really makes you think, doesn't it? How do you define that in a field as complex and nuanced as psychology? And what about the clients? How can they be sure they're getting good care?
That's a great question. What role does the Board of Psychology play in building that trust between clients and practitioners? It's a tricky balance between giving psychologists the freedom to do their work and making sure that the public is protected.
That's a really interesting point. It's something to ponder, for sure. Anyway, thanks for joining us for this deep dive into the legal side of psychology.
Always a pleasure.
We'll see you next time.